Hi, I'd like to talk to you today about durable powers of attorney. Let's start with the simple one. What is it? A durable power of attorney is a way where you could designate right now the person that you want to handle your financial or medical decision making when you no longer can. That could be a sudden incapacity, like a car accident or an illness, or it could be a situation where you become unable to act over time. Either way, it's important for you to select rather than some judge or a court to pick someone where you've had no input. When you do a durable power of attorney, you're allowed to select the person and to give them many powers that the law would not otherwise give them, including the power to do Medicaid or nursing home planning, including the power to make gifts to one or more of your children or grandchildren if you become incapacitated to help them with their college education, including the power to do ongoing estate planning, to set up trusts, and to try to structure your affairs in a way that would minimize taxes and protect them for the next generation from being taken away in a divorce or a lawsuit. So durable power of attorney, very, very powerful tool. Second, it sounds very dangerous, doesn't it, where you've designated someone to be able to do all the things that you could do if you became incapacitated. So how do you prevent abuse or control it? There are a number of ways. One way that I don't particularly like is something called a springing power of attorney. That's a power of attorney that says, nobody gets the power unless and until you become incapacitated. It sounds good on the face of it. The problem is wherever they go, the bank, a trust company, a real estate deal, some lawyer somewhere is always going to be concerned about whether or not that's still valid and whether or not you're really incapacitated. It's very, very hard for the person, the agent who has the power of attorney, to use it. For that reason, we prefer the durable power of attorney. So how do you protect a spouse who might go loony, to use the technical term, from taking your general durable power of attorney and engaging in bad financial decision making? Many people will leave the power of attorney with a lawyer, a trusted friend, or someone where they give specific instructions when it's to be given out. When clients leave it with me, I will get a HIPAA authorization from them. That's permission to talk to their doctor, and I will not give it out unless they tell me to give it out or a physician says they're incapacitated. That's one good way to protect yourself. Next, you could tell from my earlier discussion that there are two kinds of power of attorney. One's for financial decision making and the other is for medical decision making. Many people have traditionally had just one document. I like to separate it out and have two separate documents for a couple of very good reasons. One, the person who is making your medical decisions for you when you no longer can may or may not be the same person who's making financial decisions for you. Those are two different skill sets. And you might want a son or daughter who's in a medical field or a medical profession to be making medical decisions for you, while a different son or daughter who's an accountant or financial advisor to be making financial decisions for you. But it's important to separate them out. Also, most clients don't like to give their children a financial power of attorney now. They don't want their kids deciding when it's time to take over and seize control of their financial affairs. They want to make that decision. But it would be good and useful and often important for your adult children to have a medical power of attorney so that if there's a medical emergency, they could take care of it and handle it. Finally, one other point. It's important for you, if you have college-age children, to consider getting them to execute a good, durable, and medical power of attorney and perhaps a HIPAA authorization. Most people don't realize it. Once your child turns 18, you have no right or ability to communicate with their college about their grades, about their health care. You can't make decisions for them in if they're in the hospital, and you also can't even get their medical records. By having a well-drafted, durable financial power of attorney, you can handle financial issues that come up on their way. And if you have a really good, durable medical power of attorney and a HIPAA authorization for that college-age child, if there's a medical emergency, you're going to be able to participate quickly and easily in getting their medical records and helping to make the right medical decision for them. Without it, trouble. With it, piece of cake. Consider getting a durable financial and medical power of attorney for your child when they turn 18. That's it for now.